Welcome to Whatsoever More or Less, a channel where citizens diligently study the U.S. Constitution for ourselves, seeking to understand it in the tradition of the founders. Occasionally references will come from the leaders of the Church of Jesus Christ of Latter-day Saints, as our doctrine contains a divine mandate to defend the U.S. Constitution. Article 1, Section 1 is what we'll be covering today. It says, all legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives. So there are two positions of power, if you remember my 7 Ps, the Senate and the House of Representatives. Later on, we'll be getting into the qualifications for each, but for this time, we're going to be covering Article 1, basically the legislative powers, who gets it, legislative, let's look at the definition here. Having the power to make laws, so basically if something's made a law, that means it was legislated, And let's look at the definition of the word all, just because apparently some people have some confusion about this. It's used to refer to the whole quantity or extent of a particular group or thing. So I'm not putting that in there to insult your intelligence. It's just, there should be no confusion about this. So what percentage of the legislative powers does Congress have? It has all of them. It's useful to cross-reference near the end of the Constitution. There are 3 categories of legislative power mentioned in Article 6, Clause 2. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding. So there are 3 things that bind the judges. The judges don't bind to these 3 things. 3 things bind to the judges. This is, number 1, this Constitution. 2, laws made following the requirements of the Constitution. And 3, treaties made under the authority of the U.S. Now remember, Congress has been delegated all legislative powers, which is to make the law. So here we go. Brief look at the strength and strictness of each law category. Number 1, the most strict and most powerful legislative power is the Constitution. The Constitution may be amended. The process is found in Article 5. 2/3 of each House of Congress may together initiate proposing amendments to the Constitution. It takes 3/4 of state legislators to ratify. Read Article 5. Then the second is medium strictness and basic legislative power, laws. Laws become laws through the Article 1, Section 7 process. A simple majority in each House, plus the signature of the President, is usually sufficient. Read Article 1, Section 7 for more details. The third, the least strict and least powerful form of legislation is treaties. If the President proposes treaties that serve the most basic diplomatic purpose, and 2/3 of the Senate, only 1 House of Congress, approves, it goes into effect. There are some powers granted to the federal government that cannot be exercised in treaties at all. The Constitution does also clarify the power of the legislative processes, the different ones. The amendments that pass the Article 5 process shall be valid for all intents and purposes as part of this Constitution. Bills that pass the Article 1, Section 7 process shall become laws. And then treaties are more simple and limited in what they can cover. Therefore, the Constitution simply says, he shall have power by and with the advice and consent of the Senate to make treaties, provided 2/3 of senators present concur. See Article 2, Section 2, Clause 2. Honesty about what isn't in the Constitution. We are agents unto ourselves and should not bow to peer pressure to say we see something that we don't. See Doctrine and Covenants 58:28 for some perspective. Study the Milgram experiment for some perspective. Don't go along with the experts when everything they pressure you to accept violates your honest conscience. And let's look at this in the spirit of truth, So that's a reference to Doctrine and Covenants section 50. So I'm going to try to be as honest as I can. Here's some wisdom from the Honorable Ezra Taft Benson from his talk, Jesus Christ, Gifts and Expectations. The Lord said, I established the constitution of this land by the hands of wise men whom I raised up. In many of the law schools today, you will hear that the Constitution is whatever the Supreme Court says it is. Could it be that the Supreme Court, which President McKay said is leading this nation down the road to atheism, is the agency to tell us what this divine document is? Can we learn how to preserve it best by studying what it is at the hands of some of those who are seeking to destroy it? But President McKay had a better approach when he encouraged us to support good and conscientious candidates who are truly dedicated to the Constitution in the tradition of our founding fathers. They are the ones the Lord referred to as wise men. It is them, the Lord and his prophets, that we should go to determine this Constitution is. Okay? There must have been a tradition of the founding fathers, or President McKay would not have referred to it. And question, who is the final arbiter of truth? From President Nelson, The Love and Laws of God. Truth is truth. Some things are simply true. The arbiter of truth is God. This is the stance that President Benson took. The Lord said he established the Constitution. And he says, look to the Lord's prophets and look to the tradition of the founding fathers regarding the meaning of the Constitution. Now, all of my research has consistently led me to conclude that at the end of 36 years of founding presidents, some people will say James Monroe wasn't a founding president. I say he was. A lot of people will say he was too. That the overall accepted tradition of the founders that stood the test of time was just strict interpretation, or the Jefferson-Madisonian tradition of interpreting the Constitution according to the way it was written. Okay. So I just passed through a slide real quick that had some great quotes, or not some great quotes, just how AI agreed with me on that. I'm not going to read the whole thing. It's just here for your view. This is from Google AI. Okay, and I'm not going to read everything on this slide right here from Thomas Jefferson about the Supreme Court having the power to legislate, which they don't. And here's what he's going to say. You seem to think it devolved on the judges to decide on the validity of the sedition law. But nothing in the Constitution has given them a right to decide for the executive more than to the executive to decide for them. Both magistrates are equally independent in the sphere of action assigned to them. The judges, believing the law constitutional, had a right to pass a sentence of fine and imprisonment, because that power was placed in their hands by the Constitution. But the executive, believing the law to be unconstitutional, was bound to remit the execution of it, because the power has been confided to him by the Constitution. That instrument meant that its coordinate branches should be checks on each other. But the opinion which gives the judges the right to decide what laws are constitutional and what not, only for themselves in their own sphere of action, but for the legislative and executive also in their spheres, would make the judiciary a despotic branch. Now, this is from a letter from Thomas Jefferson to Abigail Adams. There's further quotes here in a letter to Spencer Roane. I'm not going to read it. Pause the slideshow if you want to. It's a fairly lengthy one, but a good one. And in that quote, or in that letter to Spencer Roane, he uses some terminology here. If you need it, feel free to look at this next slide. It has the definitions, these Latin terms. Okay? All right, so now here's some wisdom from the Honorable Dallin H. Oaks. From defending our divinely inspired Constitution, this quote is a nice compliment to what President Jefferson said in the previous slides. None of the three branches of government should be dominant over the others to prevent the others from performing their proper constitutional functions to check one another. Okay, it almost sounds exactly like what Jefferson said. Okay, and then President Oaks praises amendments, but not the Supreme Court decisions. He said, inspired amendments abolished slavery and gave women the right to vote. However, we do not see inspiration in every Supreme Court decision interpreting the Constitution. And he warns against loyalty to individuals, which Supreme Court justices are individuals. They aren't the Constitution, and they have no explicit legally binding power to define the Constitution. He says we are to be governed by law and not by individuals. And from going forward with faith, going forward with religious freedom and non-discrimination. This was a talk he gave at the University of Virginia Law School. Courts are constitutionally limited to resolving the specific cases before them. They are ill-suited to take the place of legislative lawmaking. Okay, if the founders agreed for the Supreme Court to be the final authority on the meaning of the Constitution or legislate from the bench, they wouldn't have, 1, said that Congress had all legislative powers. 2, they wouldn't have left Supreme Court rulings out of Article 6, Clause 2. They wouldn't have left the court vulnerable to be packed with partisan judges. They wouldn't have left it with no clearly laid out processes for judicial review. Everything else has a process. They wouldn't have listed out a limited set of cases over which the Supreme Court has jurisdiction. Look at the way Madison ripped on some people for thinking that the enumeration was unimportant and that a general phrase could grant endless power about Article 1, Section 8. Same principle obviously applies to Article 3, Section 2. Okay. They wouldn't have stated the simple act of Congress could create exceptions over which the courts have no authority. They wouldn't have passed the 10th Amendment, making it clear that except for Congress's power to make legislation that's truly necessary and proper to the powers enumerated, the powers not truly delegated to the federal government or prohibited to the states are reserved to the states. They wouldn't have passed the 11th Amendment, blocking federal judicial jurisdiction. They wouldn't have had every federal officer swear an oath to the Constitution, including the judges that are bound thereby, instead of an oath to judicial review. And the founding presidents wouldn't have rejected the opinions of the Supreme Court as binding on their own oath of office. Okay? All right. I have some additional text down there in the slide. Feel free to read it. Moving on for the sake of time. President Benson warned us at the bicentennial of the U.S. Constitution when he was president of the church. He warned about the courts and federal agencies. I'll focus on the federal agencies since I've sufficiently addressed the courts. We have allowed the government to ignore the separation of powers. We have allowed Congress to fund numerous federal agencies. Most of these federal agencies are unconstitutional because they concentrate the functions of the legislative, executive, and judicial branches under one head. They have power to make rulings, enforce rulings, and adjudicate penalties when rulings are violated. They are unconstitutional because they represent an assumption of power not delegated to the executive branch by the people. They are also unconstitutional because the people have no power to recall administrative agency personnel by their vote. Now, by the way, this quote I just read, it's only available in the longer version of the Constitution, A Heavenly Banner by President Benson in the book. So the one that was mentioned by President Holland when he was the president of BYU at the time this talk was delivered. Okay, a few final quotes for your consideration. John Locke, the legislative cannot transfer the power of making laws to any other hands, for it being but a delegated power from the people, they who have it cannot pass it over to others. The people alone can appoint the form of the Commonwealth, which is by constituting the legislative and appointing in whose hands it shall be. I like that word form. That's what we did. We formed a more perfect union. The people formed it. And no, the legislative branch cannot redelegate the all powers of legislation. All powers of legislation stay with the legislative branch. A few final quotes continued. James Madison, the accumulation of all powers, legislative, executive, and judiciary, in the same hands, whether of one, a few, or many, and whether hereditary, self-appointed, or elective, may justly be pronounced the very definition of tyranny. It's a terrible idea to let legislative, executive, and judiciary all lie in a rule-making agency. Madison again, nothing has yet been offered to invalidate the doctrine that the meaning of the Constitution may as well be ascertained by the legislative as by the judicial authority. Okay. In other words, they did not leave the anybody. They did not specify anybody had the authority to interpret the Constitution for anybody else. And just to clarify, the Supreme Court should never feel pressured to ignore the Constitution itself. If they are asked to rule on a case that involves a law that they find unconstitutional, they have every obligation to follow their oath and declare that they cannot participate in enforcing a law that seems obviously unconstitutional. Apparently, in the past, such as during the Progressive Era, the Supreme Court was pressured to be a rubber stamp for Congress simply enforcing the laws, and not laws in quotes because they weren't laws. Unconstitutional laws are not laws, and not first considering if they were unconstitutional. None of the founders ever argued for strictly accepting laws passed by others. If the president found a law to be unconstitutional, he was also expected to follow his oath and not enforce the Constitution. We've seen that in a previous quote earlier. This was obviously also expected of the judicial branch. Everybody's expected to follow their oath, not what everybody else tells them about their oath. According to the plain text of their oaths of office, Let's review the earlier slide. Article 1, Section 1. All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and a House of Representatives. Those are two positions of powers, okay? Legislative means having the power to make laws. If anything is a law, it's gone through a legislative process. How many powers do they have? It says all. All is used to refer to the whole quantity or extent of a particular group of thing. So how much legislative powers does Congress have? And I use the Cary Grant reference here. All of them, Frank. Okay, the Constitution is the main part of the supreme law of the land. Laws are part of the supreme law of the land if they abide the constitutional limitations. Treaties are part of the supreme law of the land if they abide the constitutional limitations. Books that filter the Constitution through the Supreme Court opinions are not part of the supreme law of the land. The Code of Federal Regulations, in other words, agency rules, is unconstitutional and is not part of the supreme law of the land. They're not laws at all. Congress has all legislative powers. The supreme law of the land is the Constitution. Amendments are part of the Constitution and are either initiated by Congress or a convention of state congresses. Laws that follow the Constitution are part of the supreme law of the land if they abide by the Constitution and they are written by Congress. Treaties are part of the supreme law of the land and must be with the advice and consent of the Senate, which is basically half of Congress. Okay, again, please like and subscribe. I'm committed to continue to be very diligent in trying to share the best content on the topic of the Constitution and the proper role of government.